Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
The first defendant opposed the suit by filing his written statement stop. It was admitted that the suit schedule property is a joint family property stop. It was contended that the second defendant was brought up by the first defendant and set off love and affection. He settled the suit property under Exhibit P1 in favor of the second defendant stop. It was further contended that the joint family property was already partitioned between himself, the plaintiff, and the other son stop. The plaintiff, having taken his share without any demur, is not entitled to maintain the suit stop. It was also contended that the suit was barred by limitation stop. The second defendant had adopted the written statement filed by the first defendant stop. The parties led evidence in support of their respective contentions and have produced the documents thereof stop. The trial court, on appreciation of the materials on record, dismissed the suit stop. Feeling aggrieved, the plaintiff filed a first appeal stop. The appellate court, after reconsideration of the entire materials on record and reassessment of evidence, set aside the judgment of the trial court stop. It was held that the settlement deed at Exhibit P1 is a void document stop. The plaintiff was granted 1/3 share in the suit property. This judgment of the appellate court was challenged by K.C. Lakshmana, the second defendant in the High Court stop. The High Court, after hearing the learned counsel for the parties and on consideration of the materials on record, dismissed the appeal by the impugned order stop. Mr. Anand Sanjay M. Nalli, learned counsel appearing for the appellant second defendant, first contended that the High Court was not justified in holding that the suit was not barred by limitation stop. According to him, Article 58 of the Limitation Act 1963 is applicable to the facts of the present case stop. Secondly, it was argued that the transfer of property by way of settlement was for pious purpose which is permissible in law stop. Therefore, he submitted that the High Court was not justified in upholding the judgment of the appellate court stop. On the other hand, Mr. Arvind Verma, learned senior counsel appearing for the respondent plaintiff, while supporting the judgment of the High Court, has submitted that the alienation by way of gift of joint family property made by the first defendant in favor of the second defendant was void stop. The period of limitation for challenging such an alienation is 12 years from the date the alienee takes possession of the property under Article 109 of the second schedule to the Limitation Act stop. Therefore, he submitted that the suit was not barred by time stop. Having regard to the contentions urged, the first question for consideration is whether the suit filed by the plaintiff was barred by limitation stop. There is no dispute that the parties to the suit are Hindus and are governed by Mitkashra law stop. The plaintiff has challenged the alienation made by his father, the first defendant, under Exhibit P1, which is a joint family property, in favor of the second defendant of family member stop.